Welcome, ladies and gentlemen, to this lesson on civil liberties. This is part 1 of 3, and we are going to focus on freedom of speech in this lesson. Before we get started, let me go over a couple of key ideas, or at least make you aware of some key vocab that I want you to pay attention to. Civil liberties, the First Amendment, prior restraint, the 14th Amendment, incorporation theory, the clear and present danger rule, hate speech, symbolic speech, this term called libel, and New York Times versus United States, a Supreme Court case, and Tinker v. Des Moines School District. So these are some important terms I want you to pay attention to during this lesson. Before we get started, let's talk about what civil liberties are. Like, what is this term? Okay, civil liberties are personal freedoms the government may not infringe upon. Okay, these are our natural fundamental rights. We have them because we exist. We have these fundamental rights because we are human, and government can't touch them. All right, this includes freedom from and of religion. We have free speech. There's the freedom of the media to express opinions, and we are secure from all unlawful searches and oppressive government. The key idea here is we need to balance personal freedoms with the rights of all citizens. So the saying goes, or a saying goes, my rights stop where yours begin. Okay, so if whatever I'm doing is not directly interfering with your fundamental natural rights, then it's okay. If what I'm doing is interfering with your fundamental natural rights, and the government must step in to stop me. Okay, I want to make a distinction here between civil liberties and civil rights. Civil rights will be the focus of other video lessons, but a lot of people lump these two terms into one category. They view them as the same thing, and that is incorrect. All right, civil liberties and civil rights are distinctly different ideas. All right, civil liberties, like I said, are our fundamental natural rights. My guys will remember this from John Locke, the fundamental natural rights of life, liberty, and property. TJ, or Thomas Jefferson, tossed in pursuit of happiness in the Declaration of Independence. These are rights that are laid out in the Constitution. Some rights are specifically identified in the Constitution. Even more are listed in the Bill of Rights. Now, there's something you need to remember. The Constitution and the Bill of Rights were created to limit government. They were not created to limit us. Okay? The people are not limited by those documents. The government is. Okay, so those rights are, think of those lists as including but not limited to. All right, those were the most important rights that our founders felt were the most key, but it doesn't limit us. They limit the government. This is very, very important. Now, civil rights, by contrast, involves equal rights under the law, okay? Equal rights for persons regardless of any individual characteristics. Now, this could be race, gender, religion. Now, sexual orientation is being debated in a much more robust fashion. Basically, this is the freedom to live one's life and engage in the political process free from discrimination. Okay, now this involves protesting against discrimination by other people against one's rights. Okay, civil liberties and civil rights are distinctly different things. Remember, civil liberties involves fundamental natural rights. We'll talk about civil rights more in other video lessons. All right, the Bill of Rights. So what is it? Well, it was the first 10 amendments of the Constitution, okay? They were added to placate the Anti-Federalists, or to convince the Anti-Federalists to ratify the Constitution. We should thank the Anti-Federalists for this, because the Bill of Rights is very important. Like I said before, it limits the federal government. It doesn't limit us. It limits the government, and it protects our civil liberties. Now, the Bill of Rights provides provides protection of rights for political, religious, or racial minorities against the majority. The founders were exceedingly worried about this. Matter of fact, Madison wrote about this in Federalist Number 10, the danger of majority faction, the ability of a majority of people to come together and exercise oppression against a smaller group of folks. Our founders were concerned about this, so included the bill. We made sure to add the first 10 amendments of the Constitution to include the Bill of Rights. Very important. So, one thing that's interesting, people kind of assume now the Bill of Rights applies to all government, and now it basically does, but originally it didn't. Originally, the Bill of Rights only protected people from the national government. The state governments were exempt. It did not protect people from state governments. It was not until 1868 with the 14th Amendment, one of 3 Reconstruction amendments, that stated there's an equal protection of the laws clause within the 14th Amendment that says all citizens are equal, or all people, not even citizens, all people are equal before the law and are entitled to equal protection of the laws. Now, what grew out of this amendment was this thing called incorporation theory. It's also known as the incorporation doctrine or selective incorporation, and this basically means that most Bill of Rights protections do apply to state governments now. But prior to the ratification of this amendment, prior to the approval of this amendment, incorporation theory did not exist. So it's important to note that originally we were only protected from the national government, not the states. All right, so let's do a compare and contrast here of freedom of speech versus restricted speech. So many would argue that freedom of speech is the heart of our government. This is important because when you allow citizens to form opinions and express those opinions to other people, it allows us to do a number of things. And you see this list right here, all right? It helps us participate in government. It helps us check inefficient or corrupt government. And it directs speech towards debate and discussion instead of fighting and violence. And when you have debate and discussion and persuasion, as opposed to just beating somebody about the head with a bat, this promotes stability in society, okay? It allows for society to be stable. Now, there have been cases in our nation's history where we have restricted speech. One of the most popular is called seditious speech. Technically, it's directed at the overthrow of the government, but when laws against seditious speech have been enacted, it's basically speech against government action. It's basically speaking out against the government and not approving with what they're doing. But we have had laws that have regulated this. World War I era with the World War I propaganda, we had a Sedition Act then. We had the Alien and Sedition Acts in 1798 with John Adams. There's been a history of the government attempting to do this. Pornography is difficult to define and something we will discuss in class as far as how the Supreme Court has ruled about it and how the state and national governments regulate it. Campus speech is protected, but schools can regulate in order to maintain public safety and preserve the learning environment. Hate speech, as much as we hate the hate speech, is also protected, but it cannot incite illegal acts. Once it does that, it is no longer protected, and the government will prosecute those people to the fullest extent of the law. So, freedom of expression. Let's talk about some freedom of the press here. So there's this thing called prior restraint. Prior restraint is basically censorship, the ability of the government to stop certain things from being printed because they don't like it. Usually they claim, a national security issue. Our Supreme Court has said no. Prior restraint does not apply. Prior restraint is censorship and therefore is unconstitutional. We have a couple of cases that you see there, New York Times v. United States and Tinker v. Des Moines School District. Now, in New York Times versus United States, there were these Pentagon papers that basically had all this information about the Vietnam War, statistics, deaths, things that were happening in the war that the government was not releasing, were not allowing the people to know. New York Times got a hold of these Pentagon papers and attempted to publish them. The government tried to stop them, but the court said, no, honey. No, sorry, government. You're shut down. The Pentagon papers were published and the freedom of press was protected under this case. And despite the fact that government claimed we need to keep it out of the papers for national security, the court said, no. Not worth it. Free press is more important. In Tinker v. Des Moines, the Supreme Court ruled in favor of symbolic speech, where students could wear black armbands to protest the Vietnam War. The school tried to stop the students from wearing it, and the Supreme Court said, no. They get to wear it. That's part of their right to free speech, symbolic speech. We'll talk about that more in a second. So, symbolic speech is the use of symbols rather than words to convey ideas. So that is protected. It's just as if I were to say it versus if I were to show it, it's the same thing. Okay, it's protected speech. Commercial speech is protected to a point. It is legal, but it's able to be regulated by government. So there's a lot less protection here than other forms like symbolic speech or actual speech. There are certain permitted restrictions on expression. One example is the clear and present danger rule. So this is laws cannot punish speech unless there is or was a clear and present danger of harmful actions resulting from that speech. So if the government, in order to fulfill its constitutional duty, needs to maintain the peace, they can punish certain kinds of speech if it meets the clear and present danger test. There are some modifications. The grave and probable danger rule basically ups the ante on clear and present danger rule. If such speech would be so dangerous, so disastrous, then the government does have a right to interfere because they have a constitutional duty to prevent danger. All right, so let's talk about a little bit about student speech, which I know you're all are listening very closely to see just how much you can push this envelope, right? So the Warren Court, and this was Chief Justice Earl Warren during the 1950s and 60s, he said that schools must allow free speech. They cannot disrupt the schools, but political speech is an exception. So they can't disrupt the learning environment unless they're speaking politically, in which case nobody can stop them. Berger and Rehnquist, which were courts that came a little bit later, Chief Justice Rehnquist and Chief Justice Berger, they said that they can restrict speech. Schools can restrict speech for educational purposes. And they can also restrict speech or clothing that is lewd, vulgar, or that promotes sex, drugs, or violence. So this is why school uniforms are in fact legal and why schools can say, no, 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 honey, you cannot wear that t-shirt. Now, schools can also censor student publications, but any web pages created off campus are protected, unless, again, they urge illegal action or make terrorist threats, in which case the government and or school can step in. Demonstrations. That's been a big topic of conversation in the news lately. So in a public forum, individuals are allowed to use public places for protest. They can use sidewalks, parks, theaters, grounds around public buildings, any number of areas. But you cannot disrupt activities. So if you're going to block traffic, or if you are going to interfere with regular activities that are happening, then you can be arrested. You can be arrested, and your right to protest and speech does not extend beyond disrupting the activities of other people. Private property is excluded. You have to get the owner's permission. So if you want to protest a corporation's actions with, say, sweatshops, you can't just go onto their property and protest because you have to have their permission. It's private property. You can't go on there. Neighborhood marches are okay, but you can't focus on a particular house or houses or a particular place. You have to just simply march through the neighborhood. And government can do these things. It can require a permit. It can establish restrictions to avoid disruptions, but it cannot censor. It cannot determine what you can or cannot say. However, they can require a permit, and they can make sure there are restrictions to avoid disruptions. For example, they might direct the protest to go down a certain side street or to remain in a specific area in an effort to maintain the peace. And they are allowed to do this constitutionally. So here's a lovely little cartoon for you here. When we're talking about hate speech is speech that is directed against a specific group of people. It's not an individual. It's because of your sexual orientation or your race or your gender or your religion. So something to that effect. So even though we may not like what some people say, as you can see down here, talking about the Nazis, they still are protected. As long as they're not inciting violence, they have a right to spout their hate. And so you see this political cartoon, this graphic, you say this is the bench of the Supreme Court, and up here you have the justices, and they're staring at the First Amendment. Down here you have the Nazis wanting to engage in a protest. And one justice says, I've already looked. I tell you, there's not a thing in here that excludes scum. And that's right, there isn't. People as distasteful, as disgusting as we might think the things they say are, they still have a right to say it. And that's a beautiful thing, and let me tell you why. Because if they have a right to spout their hate, I have a right to spout the opposite. I have a right to go and share my views with other people and attempt to convince them to agree with me and not those guys. And that is the beauty of the First Amendment. Now, like I said, the defining characteristic is advocacy versus incitement. You can be very enthusiastic about your opinion, but you cannot incite people to violence or to participate in other illegal activities. That's very, very important. And that's it for this part 1 of 3 lessons. I will see you in part 2.